We now call 24 CR 1242, the state of Texas versus Corey Hillman. That's you? You have to speak out. So you shouldn't, presently, Mr. West, your attorney and the state's attorney, does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment, which was handed up on June of 24, states that on or about May 7th, 2024 in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you were charged with here?
Yes, sir.
If convicted of a third-degree felony like this, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range you were facing, sir?
Yes, sir.
An agreement's been reached where you would be pleading guilty, sentenced to 6 years in prison. That would be suspended. You would be placed on regular probation, which can be up to 10 years in length on the probation. Fined $500. There will be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this third-degree felony of evading arrest or detention as charged in this indictment? Guilty or not guilty? I just ask a question. Guilty or not guilty?
Yes, sir.
Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty?
Yes, sir.
Okay. That was a pregnant pause there. Show you what's marked as State's Exhibit 1. Did you sign it?
Yes.
Understanding. Discuss it with your attorney or the contents true and correct.
Yes.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. This states, among other things, that you are mentally competent to enter your guilty plea freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All true, this states, so help you God. Is that so? States Exhibit 1, part of the record for all purposes. Please send your report as well.
Please, Your Honor. Yes.
Anything else to add, State?
No, Your Honor.
Our defense.
The only thing is, as we did, I know it's a discretion on the amount of probation, but we, through negotiations, agreed to 6. I just want to make sure I was aware of that. Yeah.
Anything else?
No, nothing, no.
If not, then I'm going to make the findings that you are pleading guilty, sir, voluntarily. You are mentally competent. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of evading arrest or detention with a motor vehicle. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. That will be suspended. You are placed on regular probation for 6 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. You will be fined $500, among other things. You're going to have to successfully complete a defensive driving program, which is a win-win because your insurance will go up because of this, but will go back down for taking defensive driving. So it's a kind of a quid pro quo equitable remedy there, but it is normal and customary for this type of offense for that as a condition of probation. And there will be other terms and conditions that are normal and customary. Please follow them. If you fail, your probation could be revoked. You could be sentenced up to 6 years in prison. So fix this. Probation officer is going to talk to you and go over those. You'll review them and sign them and begin probation. Good luck.
She's in report. I think she's on this today on probation.
It's just this. I don't think it's going to file in this court. So, but it's
Well, you've been on probation.
All right,
June 4th.
24 CR 577 is called your Terra Hoff property.
Speak up.
There's a motion to revoke unadjudicated probation here that's been filed against you. You're on a Class A misdemeanor assault as of June 4th, 2025. You were charged here originally with the second degree felony of assault on a peace officer. Then it was reduced to a Class A misdemeanor assault, and that was in June of this year. And there's a DWI. This states you committed driving while intoxicated on October 21st. So that was about 3 or 4 months later. And then also you failed to never become intoxicated by being under an influence of some intoxicating substance on that day, which is a different condition of probation that is alleged you violated. Failed to provide verification of performing community service hours as required, and failing to abstain from the use of any and all intoxicating substances. Those are all different conditions of probation that it is alleged you committed, and it looks like from that event in October. So we're going to have a motion hearing on this as soon as possible. I'd like this set for next week if possible.
You can do that. Lab results back here.
Okay.
We just want a bond.
I want a hearing as soon as possible. When can we get those back, do you think?
I'll need to, I'll have to contact the agency. Just give me a call.
Did they do one? I mean, they took, I guess,
Did they do a blood test?
something from them.
Evidently there was a
but-
blood test.
But okay, what are you asking for?
A bond.
Okay, what's state
Blood,
state?
blood was collected to go back to answer
Okay.
that question.
If we can get that hastened, that'd be nice. Because I don't want, the motions have been,
As of right now, I cannot speak as to timing because I didn't know that this is the direction it was headed. I'll have to contact the agency and find out, Your Honor, where we're at with that. As far as that goes, we can move forward with a hearing if Your Honor wants to do that. I can get the law enforcement agency here. We can work without the case being filed.
I think a lot of it has to do with the results, huh?
It would.
Okay,
Whether
But according to the PC, there's field sobriety tests that were done, and the officer can talk about that. I can prove intoxication without the blood test.
I'd like a blood test.
Yes, sir.
Thanks.
Yes, sir.
So, what about the bond? He's just saying a bond, and he's not even descriptive. What are you, what kind of
Well,
bond are you
it's
talking
misdemeanor.
about? I know it is. What are you talking about?
It's deferred. She's entitled to a bond, Your Honor.
Okay, you're going, I'm going to grant a bond of $5,000 in this case, but you cannot operate a motor vehicle, period, on my watch until we get this resolved. Do you understand?
Yes, sir.
You're going to have some other way of getting around. And then also you what is it that we want to do for the alcohol? I want to.
Probation officer is suggesting the drop program, Judge.
Oh, that's she was to install the inner one.
And then, no, I want something else. What else
Interlock
prevent
device.
from alcohol?
Well, sure,
Seems to be a problem.
he's not driving. It'd have to be scram. If he wanted to do something. She is employed, re-employed,
Excel group.
doing
Electrical,
electrician,
yes, sir.
electrician work. What?
Okay, there was vodka in the center console. Okay. So we need to get something that, what device?
Scram device.
The scram device,
All right. And where did she acquire that?
recover, I believe they have one in Liberty. That's the closest.
Okay, and that, how does that work?
It's on around her ankle and it monitors it through her slide.
Okay, that will be ordered as a condition. We're gonna fix this mess.
All right, just when you get it out, you'll have to get the scram installed and see what the
And
bottom.
Liberty.
I don't know where you go.
I can guarantee you. It's fine. Goes on your copy on the
Yes.
shed.
You'll see that. It's not dry.
This was the last of October.
That's about
Maybe I
it.
could come tomorrow. Tomorrow.
You get back to work.
Yes, sir.
Mhm. Very difficult without being able to drive, but try.
That's Uber. We can see
You can't
what.
operate a motor vehicle until we can get this disposed of.
That's just
Sir.
talks with it still.
It was said this for a motion to revoke hearing as soon as possible. I have Reginald Allison here, okay?
We were wanting to buy.
There won't be I don't accept deals anymore, except right
Okay.
now, okay? There's a motion to revoke unadjudicated probation that was filed August 25th. You were charged with aggravated assault, 10 years for probation. You were ream provost?
Yes, sir.
Failing to provide verification of performing community service hours, failing to provide verification of participating in GED, failing to pay court assessed fees, failing to have a GPS monitoring system installed.
Judge, I filed an amended motion last week. I don't know if you're looking at that.
Didn't get in there.
I saw it was accepted. I
Failed to surrender his Texas driver's license at the time of the judicial review.
That's the GED part.
I don't have, do you have a copy of it with you?
I'm trying to find one out right now.
He entered the program. He enrolled in Illinois. I guess he didn't get the GED, but they let him enroll in college. Yeah. You got that? Okay.
Okay, I can come over soon. All right, yeah, Jimmy, we don't have the proposed orders yet.
There's no proposed order. There's, because he was already out on that. I just did the motion.
You got a thing showing you.
Okay.
There was a mistake, Judge. The original motion didn't include one of the administrative hearings, so everything that was added was from the additional administrative hearing.
Um, Among these others, it states he failed to enroll in complete online drug education course in violation of a hearing held in May 14. Failed to never commit an offense by being public intoxicating by having committing the offense of public intoxication on or about April 14th in Port Arthur, Texas. Failed to never use or possess a drug by testing positive for marijuana on April 17th. Failed to not become intoxicated under the influence by being arrested for public intoxication on April 17th. The problem I have is this. I don't know what I'm supposed to do, if I'm supposed to release him home confinement and he's failing to have a GPS monitoring system. There's no way we can, I mean, there's no way we can figure out where he is. Right?
I think if Mr. Prevost could address that, how will the court know where you are if the problems on GPS system?
I want a GPS. That's what we normally have. And what was his problem about having it from probation?
He said he couldn't afford it at the time, and as of today, he's built up enough to device installed.
How long has it been?
He's been in jail, what, today makes 14 days? Yes, sir. And he has 2 positive drug screens. His drug of choice, judge, is marijuana. And what upset my supervisor on a day of a hearing, he presented us with a compassionate use registry where he could legally use marijuana. And the doctor's excuse was he was diagnosed with PTSD. But I never received any type of documentation from Mr. Prevost that he had any type of mental health issue.
Okay. You have to have a foundation to support something like that. But I'm more concerned about him ambling about. I was not knowing where he is when he didn't have a GPS device. When can we have a motion on this hearing?
Hearing on this motion.
Yeah, a hearing.
I can do this relatively quickly as well, Judge.
Can you do it in 2 weeks?
Yes, sir.
All right.
Go ahead and turn it to Mr. Hampson.
All right, I'll hold this in consideration. We're going to have this hearing as soon as we can.
So there's no bond?
No. And if he's unable to have a GPS device, there's no way we can really keep an eye on him. Gary Budro is next. Gary Budro. Yes. Correct. Is that right? Yeah, sophomores. Is Mr. Adams your attorney?
Yes, Your Honor.
You were charged in 2 cases, 25 CR 873 and 874 with the first 3 felony of aggravated sexual assault with a child and indecency with a child by exposure. First degree felony and aggravated sexual assault, you were looking at up to life imprisonment if convicted, and then the indecency up to an additional 10 years in prison in that case. What are we doing on these 2?
Judge Austin is 30 years in prison TDC. He's saying, no, that's a trial.
Okay, that's right.
I want to try to fight from Anderson. So that
Or is that right? You want to trial it?
No.
You're not accepting the deal, so it's going for trial, right? That's what. Yes. There's only have 2 choices. You're either going to accept the offer or it goes to trial. Which one is it, sir?
You said that you're going to fight for
Which one?
trial. That's what
You have to speak out in English for the record. What is it you want? You've got 2 options here. He's talked to you. I know about it.
Necessary. I'm trying to. Question is, you said you want to fight for innocence, but you want a trial or not? I don't want to trial. How you gonna do that?
There's only 2 choices. Pay attention closely. It's either the option of an offer that's been made to accept it or go to trial. Those are the only 2. Huh? Well, over here.
I'm taking it from.
Okay. It's set for trial. This will be we'll set first the aggravated sexual assault, the first degree. Over here is we're over here. We're going to set this for trial. When can you be ready? This is going to fast track. We're going to get this thing done as soon as possible.
Whenever you ready for it, Judge, I
Can you, Mr. Am, can you be ready in a few weeks?
Whenever you said it, Your Honor.
All right, it'll be ready next month. Next month. Thank you. That is all.
Thank you, Your Honor.
Next is, I've got Gregory Woods.
Who?
Gregory Woods, that's on. 'em. Okay. Jacoby Diamond Broussard.
Who?
Jacoby Diamond Broussard. Okay. Gregory Woods, that's on. Okay. Jacoby Diamond Broussard. 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 Langston. The state of Texas versus Paris Ross, present with his attorney, Mr. Adams, and the state's attorney. Does the defendant waive formal readings of these indictments? Can we proceed in summary?
Yes, sir.
In summary, each of these indictments, sir, allege similarly that on or about October 19th, 2023 in Jefferson County, Texas, it is alleged in 25 CR 381, you committed the second degree felony of fraudulent possession or use of credit or debit cards. And in 25 CR 382, it is alleged you committed the third degree felony of forgery of a financial instrument purporting to be a U.S. Treasury note being purportedly a $100 bill, which was a forged instrument. Do you understand what you're charged with in each of these cases, sir?
Yes, sir.
In 381, you're facing a second degree felony, which means you're looking at no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. And in 25 CR 382, it's the third degree felony of forgery of a financial instrument. You are facing no less than 2, nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Missed that one. You think you're checking a box, and the way this thing works sometimes, it goes to another box that you didn't intend to check.
That is true.
An agreement's been reached, whatever sentence shall not exceed a cap of 4 years in prison on each of these cases to run concurrent.
Yes, sir. And the dismissal.
Which and a misdemeanor, illegal possession of controlled substance, would be dismissed. So we are looking at then options of no less than 2, nor more than 4 years confinement in prison. You could be placed on deferred or unadjudicated probation for up to 10 years. You could be sentenced to no less than 2, nor more than 4 years confinement in prison. And that could be suspended, and you could be placed on regular probation for up to 10 years on probation. I think those are all our 3 options. If I follow this agreement, you have no right of appeal of your case. Do you understand? In each case.
Yes, sir.
How do you plead in each of these cases? Guilty or not guilty?
Guilty.
What do you say?
He said guilty.
Are you pleading guilty voluntarily? That is, on your own free will, and because you are guilty in each of these cases, sir. I show you what's marked as State's Exhibit 1 in each case. Did you sign those documents voluntarily, understand them, discuss them with your attorney? Are the contents all true and correct? State's Exhibit 1 in each case tendered into evidence without objection?
No objection.
Admitted. Among other things, this states that you are mentally competent to enter your guilty pleas. They are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You were guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states in each case, so help you God. State's Exhibit 1 in each case is made a part of the record without objection. State and defense?
Correct.
Right. Yes, sir.
Oh. What we're going to do is order a pre-sentence report. I'm going to ask you to please, or direct you to please see the probation office to begin that now. And then what we will do is all parties will have a chance to add any additional information. We're going to return back for sentencing on
January 20th.
January 20th, 2026.
Is that,
And then the court will hear arguments and make the decision in each case. Do you understand what has happened today, Mr. Ross?
yes, sir.
Okay, please see the probation officer. Thank you.
Judge, I just need him to sign a resetting form.
Let's sign this first. She's the boss. Sign that resetting on is January 20th good?
I was trying to, honestly, Judge, I borrowed 1,500 just to come down here. Like, I'm kind of late on my rent. I literally need, I'm not trying to be funny. I'll be here whatever date y'all set. Like, I just need
You need a little bit more time.
to like,
Can you give him February?
I literally need a little more.
I'm going to set it for January 20th. Call me back on something y'all can decide on that's close to that and that the state and y'all can agree on, then I'll work with. Okay.
Yes, sir.
All right. But we're going to set it on a date certain. Then I'll change it if everybody can agree on something at a later time. Okay. Y'all talk about it.
Yes, sir.
All right.
It's changeable.
That's not a problem.
Yeah.
So,
But yeah, we got to do a sentence. We got to do it. We have to have a pre-sentence report, and that takes some time. We can't do it in a minute or an hour. It takes some time for everybody to be heard. Then they've got to prepare it in writing. Then it's sent to everybody to see and then come back together. And then each party gets to be heard on their thoughts and additions or changes to it.
yes, sir.
But that's a soft date.
Yes, sir.
Okay. But it's going to be close to that date.
Yes, sir.
Okay. So just let us know and then everybody can make arrangements. We're going to do it early next year. No, postpone it long. Please, get the resetting. Thank you. And keep up with